I only speak of the Métis Nation because that's really, to me, the only collective of Métis people that one can speak of. That is, they are a group of people that had indigenous marriage patterns. They have a kinship system. They have a geographical location. Today we talk about, the Métis politicians talk about Ontario West to BC, but the historic Métis Nation would be part of, it would be the fur trade country and be centered around the Parkland area. So one of the key backbones of the Métis Nation would be the Carleton Trail from Edmonton through to the Red River country, to what is now Winnipeg. And in that area, because this is a very good question, this decision pertains to the postage stamp province of Manitoba. After that, Métis were dealt with slightly different, but with some of the similar outcomes, and some aspects of it were founded on how the Manitoba Act was implemented, and that is this business of what was referred to as half-breed scrip. Now, what the court was able to do in the Supreme Court is kind of create an argument that avoided the issue of limitations and latches. Limitations are, you have a certain time to act on when you have a problem. You can't leave it for years and years and years. Although this doesn't apply to First Nations, we have actions occurring concerning dubious reserve surrenders, or we have treaty land entitlement shortfalls on the original reserve surveys occurring many decades after. So the limitations problem looks like a tricky bit of European law being applied to oppress injustices of the past. So the court got around that. The previous courts hadn't, and then latches, the whole idea that they sat on their rights. The dissent and all previous court decisions pointed out the fact that this all sort of looks like an afterthought, that the Métis just sort of wake up to it. They should have acted on their rights a long, long time ago. It's unfair to the Crown now for the Métis to come forward. So one of the advantages of this decision is that it is possible to craft a legal argument that circumvents the problem of limitations of actions and the problem of latches. So elsewhere you have a script system that's implemented that's filled with fraudulent practices. Agents of the Crown make admissions of these fraudulent practices, and so that's there. I mean, the evidence there is far more damning in terms of dishonor of the Crown. In fact, we would have to say these are sharp dealings. Now, in several previous court decisions by the Supreme Court, they make references to sharp dealings. And we don't get these references to sharp dealings in the Manitoba Act case, the MMF case. I haven't seen, I could be totally wrong, I haven't seen a reference to sharp dealings, and I think that's very interesting. Nonetheless, Northwest Scrip, which was an entitlement to land for Métis, that was issued from 1885 through to about the 1920s in a certain respect, to a vast area of the country outside of the postage stamp province of Manitoba. And the outcomes are very similar in the sense that no real Métis land base was created. It was just something that, an ephemeral sort of thing, and then they got some cash for it from some speculators. But the very essence of Métis scrip to me is sharp dealings. It's filled with sharp dealings. So the problem, though, that does not suggest that it will be an easy fit to go from the honor of the Crown in the case of Section 31 and Section 31 of the Manitoba Act of 1870, which is now referred to, which then the Imperial Parliament put their hands on it, and it became then the British North America Act, of 1871, which we refer to as the Constitution Act 1871. So Section 31 had with it this constitutional dimension, which is why things like limitations and other things may not have been germane. There has been a remedy on the French language aspects of the Manitoba Act. That came in. It didn't seem to be a problem of limitations. And again, you have a number of issues of reserve lands that come well past any sort of six-year limitation. But the entitlement of Métis scrip is based on statute. It's based on the Dominion Land Act. And whether the business of the Honour of the Crown can have any relevance to a action by the Métis on scrip, I would not be sure about. And so I'm not sure that there would be a remedy there.